Here's an interview with CBC and Conservative MP Michael Chong, who sponsored the 2014 Reform Act. This act explains how a political party of the House of Commons is legally allowed to remove a member from their party, and how Justin Trudeau and the Liberal Party, once again, don't care for the rules.
It's been nearly 24 hours since the Prime Minister announced to his caucus that Jody, Wilson-Raybould and Jane Philpott were out. It wasn't a caucus vote that cemented their fate, though. Justin Trudeau says he made the call after consulting with caucus chairs. He said based on those conversations, it was clear Wilson-Raybould and Philpott had lost the confidence of their Liberal colleagues. Did the Prime Minister follow the rules here, though? Michael Chong is an Ontario Conservative MP who sponsored the 2014 Reform Act, and he joins me here in studio. Hi, Mr. Chong. Nice to see you.
Nice to see you.
Thanks for coming in. Let me just ask you to first lay out what your bill, which was passed, what are the rules under which Jody Wilson-Raybould and Jane Philpott would be able to be kicked out? Like, how would that work?
So the first rule, which is the caucus expulsion rule, says that there's a two-step process. First, 20% of the caucus had to have written to the caucus chair requesting an expulsion vote. And then second, a majority of caucus, not just members present, but a majority of the entire caucus would have had to have voted on a secret ballot to expel in order for the expulsion to take place. So in the Liberal Caucus, there had been 179 members. That meant that at least 36 Liberal members of Parliament would have had to have written to the caucus chair. Once he received at least 36 letters, he could then call a caucus, of secret ballot voting caucus, on the expulsion of Ms. Wilson-Raybould and Ms. Philpott. If 90 members of that caucus voted to expel, then they would have been expelled. And if only 120 members showed up for that vote, you still require 90 members.
So there had to be a vote.
There had to be a vote, and it had to be an absolute majority of all members, not just members.
Okay, here's what the caucus chair said about that. That's not the way we do things in the National Liberal Caucus. We don't vote typically. We never opted into the rules that were suggested by the Conservative Private Members Bill by Michael Chong. We operate by convention, and our party's convention is that membership in caucus is determined by the leader of the party, informed by caucus, of course. So his assertion is that essentially an overwhelming majority of caucus did support this. That was conveyed to the Prime Minister, but ultimately the party and members of the party decided that the Prime Minister makes that decision. Well,
it's shocking to hear that from a sitting member of Parliament because it's a clear undermining of the rule of law. It doesn't matter who originally sponsored the bill, whether it was a Conservative MP that introduced a private member's bill or a Liberal MP. The bill became law. Parliament decided to adopt this bill into law. It became law, and it's the law of the land. And the law says that at the first caucus meeting of a caucus after a general election, 4 recorded votes are to take place, determining the power of the Prime Minister and the power of Liberal MPs. Those 4 recorded votes did not take place in direct contravention of the law. It is illegal, and it's a violation of the law.
Okay, let me flip it around a second, because didn't Andrew Scheer expel Senator Lynn Beyak from Conservative Caucus without going through that whole process?
That's correct, but Lynn Beyak, these rules only apply to the House of Commons caucus.
So it doesn't matter if you're a senator?
It doesn't apply to senators. The rules in question here about the expulsion of a member concern only elected members of Parliament who sit in a House of Commons caucus.
So I remember when the discussion around Maxime Bernier was happening, for example. Was it Andrew Scheer's intention? Do you know, like, was he going to follow all those rules if, in fact, he was going to? Was that commitment clearly made?
Absolutely. In fact, I can tell you that not a single member of the Conservative caucus has been expelled in this Parliament. Why? Because the Conservative caucus adopted that first rule at our first meeting on November 5th, 2015.
So there's no way Andrew Scheer would kick somebody out unless he had followed all those rules that your bill lays out.
That is correct. In other words, that is correct. The only way for a Conservative MP to be expelled from the Conservative caucus is for that 2-step secret ballot process to take place.
Okay, the Liberals say that's not the way we want to do it. We're not going to opt in.
I'm sorry, in this country we have the rule of law. It's enshrined in the preamble of the Charter of Rights and Freedoms in the Constitution Act 1982. Parties don't get to pick and choose what laws they follow. This is how we got into this whole SNC-Lavalin mess in the first place. A flagrant dismissal of the rule of law. It is the law. It's in the Parliament of Canada Act. It's an act of Parliament, Section 49. They broke the law.
Okay, let me ask you on a broader scale, because your party has certainly been critical of the decision, not just to kick them out, but of what the Prime Minister has said on all of this. If a cabinet minister secretly recorded a conversation with the clerk of the Privy Council and made it public, don't you think if it was Prime Minister Andrew Scheer, he too would kick somebody out for that?
Well, clearly taping that conversation was inappropriate, but let's not get distracted by the heart of the issue here, which is that the independence of our prosecutorial function was violated. the Shawcross Doctrine was violated. And it was violated not just once, but multiple times during the fall. And I think the
Has
Attorney
that been
General,
concluded, though? I mean,
I've concluded that. I think it's quite clear. I think if you look at the testimony and the evidence, whether it's taped evidence, which maybe have gotten inappropriately, or it's written evidence, documentary evidence that's been submitted to the Justice Committee, it's clear that that line was crossed. If it hadn't been crossed in September, on September 17th, it certainly had been crossed by Christmas.
I mean, the Prime Minister insists, though, that they weren't crossing a line, that they were raising the issue of jobs appropriately so. And the evidence would seem to back up the fact that I mean, they're not saying we want to do something illegal, right? They're saying, in fact, the opposite.
I think the important thing is this. The Shawcross Doctrine clearly states that it is okay for the Attorney General to solicit her cabinet minister colleagues' advice on a particular file, but it is not appropriate for those cabinet minister colleagues to put pressure on the Attorney General with respect to the
They just
case.
say they weren't putting pressure, though. They say they're just raising the issue.
I think there clearly was pressure, clearly.
Why do you think it's so clear?
Well, I've been in cabinet and I know what it's like to get a phone call saying that the PM wants this done in a certain way in this town. That means, you know, a huge amount of pressure is brought to bear. There's no ifs, ands, or buts about it. And anybody...
Is that inherently wrong, though?
In this particular case, it was, because it violates the Shawcross Doctrine. And the issue here is that the unwritten Constitution, as the Supreme Court mentioned in its 1981 patriation reference, the unwritten Constitution is not justiciable in the court system. The only branch of our system that can adjudicate a breach of an unwritten constitutional convention like the Shawcross Doctrine is the legislative branch of our system, the House of Commons. But the House of Commons, to this point, being under the thumb and control of the PMO, has been unable and unwilling to bring this matter to a resolution.